If you're a business owner or high worth net individual here in Florida, July 2025 brought major federal tax law changes that affect how you should think about asset protection, estate planning, and business structuring going forward. I'm Mitch Green, an asset protection attorney here in Florida. My focus is helping business owners, professionals, and families safeguard what they built from legal risk, creditor claims, and unnecessary tax exposure. With the One Big Beautiful Tax Act now signed into law, many tax provisions that were set to expire have been made permanent, and there are new planning opportunities you should know about. What changed and why does it matter? Let's start with estate and gift tax planning, critical for asset protection. The Act permanently extended the higher estate and gift tax exemptions from the 2017 Tax Cuts and Jobs Act. For 2025, that's approximately $13.99 million per individual, or about $28 million for a married couple, indexed for inflation going forward. Those exemptions were set to be cut in half at the end of 2025, but are now locked in permanently. What does that mean for you? If you have irrevocable trusts, family limited partnerships, or dynasty planning structures, this permanency gives you long-term certainty. You can now plan major wealth transfers and asset protection strategies without worrying about the rules changing in a few years. For business owners, the Act made the 20% pass-through business income deduction permanent. If you operate as an S corporation, partnership, or sole proprietorship, you can continue to deduct up to 20% of your qualified business income. This is huge for Florida entrepreneurs who structured their businesses to take advantage of this deduction. The Act also created several new temporary deductions running through 2028, including no tax on tips for service workers, no tax on overtime pay, an additional $6,000 deduction for seniors aged 65 and older, and a deduction for car loan interest on personal vehicles. But not everything is favorable. The Act includes tighter limits on itemized deductions for high earners, a lower alternative minimum tax threshold, and the expiration of several clean energy tax credits. These changes could mean higher tax bills for some high-income individuals. So, with all of these changes, what should you do? Here are the key action items for 2026 and beyond. Review your estate plan and trust structure. With permanent higher exemptions, you may have new opportunities for wealth transfer that were not available before. If you created trust years ago, assuming lower exemptions, it's time for an update. Optimize your business structure. With the permanent 20% pass-through deduction, make sure your business entity type is still the best fit for you. Some business owners may benefit from restructuring to maximize the deduction while maintaining asset protection. Reassess income and investment strategy. With new deductions expiring 2028 and changes to itemized deductions, your tax picture may look very different. Work with your CPA and attorney to model out the next several years. The key is coordination. Your legal and financial advisors need to work together to ensure your best asset protection strategy works with these new tax laws, not against them. These opportunities are significant, but so are the pitfalls if you don't plan correctly. If you're a business owner or high net worth individual in Florida, I want to make sure your asset protection and tax strategy is optimized under the current tax law. Let's talk. We can review your current structure, identify opportunities you may be missing, and make sure you're positioned to protect what you've built while minimizing your tax exposure. Reach out today. The best planning happens proactively, not reactively.